Good evening. Happy Monday. We've had a new filing, document 91, in the Decastro versus Abrams et al. Case. And it's amazing. It's perfect. I don't know who Chili had write this for him, but I can't find a single fault in this. This is quite possibly the best pleading I have ever seen. And I'm lying, just in case you were unaware of it. That was a complete and utter lie. This is shit. This is pure unadulterated shit. This is Chili's supplemental points and authorities for plaintiff's motion to dismiss Joshua Abrams' counterclaim to his lack of subject matter jurisdiction, his 12b1 motion. He says counterclaim is also not logically related, a part of the same case or controversy, and therefore requires an independent basis for justification. And he cites McCaffrey versus Rex Motor Transport Incorporated at 672 F 2nd 246, page 249, First Circuit, 1982. Now, he managed to get the citation correct, and I appreciate that. He's got the citation with the actual page number it's found on, and that's perfect. That's chef's kiss right there. But I've had this problem before with discussing law. I don't know if any of you remember it, but there was some pleading thing that he thought you had to do. And to cite, in order to support his proposition, he cited a case, a district court case from like the 80s that was before Rule 9, if I remember correctly, it was Rule 9 of the Federal Rules of Civil Procedure, was changed by Congress before Congress amended it. And now we're doing this again. He is citing a case from 1982 that is no longer good law. This is, again, First Circuit. This is from 2010, so this is about 30 years later. And they say, in an issue of first impression for this court, we hold that 28 U.S.C. Section 1367, enacted in 1990. This was 1982, so this was enacted in 1990. Gives federal courts supplemental jurisdiction over both compulsory and at least some permissive counterclaims. This alters this circuit's former rule, adopted before the enactment of Section 1367, that required permissive counterclaims to have an independent basis for jurisdiction. See McCaffrey versus Rex Motor Transportation Incorporated, 672 F 2nd 246. They cite page 248. It's the same case. First Circuit, 1982. Our ruling brings us into line with the Second and Seventh Circuits, as we describe below. So it's never good to cite a case for a proposition where that case has been overturned. There is a term for what this is. It's called shepherdizing. There used to be a book called Shepherds, I believe, where you could look up a case, a citation, and you could see if there were any subsequent cases that overruled it or cast doubt on that particular, distinguished it. So a quick rule of thumb, and an easy thing to do that I like to do, I know I haven't gotten very far into this, and I apologize if you're just looking for me to read it. I'm going to give you some helpful tips and tricks on the way there. If you don't have an expensive Westlaw account or an expensive LexisNexis account, what I like to do is I like to search for the case name. So you search for everything. You don't need that. But then you go into Scholar, and then you go into Case Law, Select Courts. We're still looking for First Circuit Court of Appeals or Supreme Court, and done. And you just paste as plain text. You can put your little quotations around it, and boom. You see, you've got these three. So you find the most recent one and you read it because it'll have all the previous stuff in it if necessary. And then when you look it up and you get down here, you see, oh, here they're citing it. And then you could just read the little blurb about it and all of a sudden, oh no, that particular proposition of McCaffrey versus Rex motor transportation is no longer good. That's the quick and dirty way of doing it. Obviously, there's better ways out there, but that's the 10-second, YouTube attorney way of doing it. So he is citing bad law, so that's not going to help him. Then he has a request for a hearing. Pursuant to Local Rule 7.1d, I hereby request oral argument at the court's election on the issues presented in this motion. Now, oral arguments are not something that the court has to grant. It is something that the court can, at its discretion, grant. And the reason why the court would grant oral arguments is because the facts in the law, when the court looks at them and tries to weigh and measure them, they're close. They're close enough that if an attorney or a litigant, I guess I should say, is able to maybe distinguish some of the cases, maybe in the argument kind of help the court understand why the court should see it their way instead of the other party's way. That's when the court does it. It's when things are close and they really want to make sure that they give a good, correct ruling because it's not exactly clear. It's not cut and dry. So that's when the court will grant a request for oral argument, or even just say, I want you guys to argue this. There's going to be an oral argument on it at this date and time. In California, at least in the circuits in the counties that I practice in, generally speaking, in civil, there's usually a tentative ruling that comes out. So there's a set date. You get a date for the oral argument. But then a tentative ruling will be published maybe anywhere from like a day before to a week before, I guess, maybe even longer for probate. But that'll, like if the tentative ruling says, hey, no oral argument, I'm going this route. If you want an oral argument, you have to request it by the state or something like that. But even then, I remember Judge Brown in Sacramento County Superior Court, he did a lot of the civil stuff. He would always remind everybody in his courtroom there for oral arguments that oral arguments are a privilege and he does not have to allow you to make an oral argument. He can, at his discretion, just make a ruling based on the pleadings. In ECF number 52, this court said, quote, the court will not now transfer the case because plaintiff has had a change of heart, as appealing as that option may be. So what the court was saying there, I don't know if you guys remember, is Chile had filed in Massachusetts. And then Chile's like, wait a minute, I want to actually do this in California. It would be more convenient for me and more of a burden to Kate and Josh if this was in California. So I'm going to file a motion to transfer it. And the court said, no, you selected this court. As appealing as that option might be for you to have a change of heart and for this to get out of my hair, I can't just do that because, well, there's rules. And you selected this forum. You're stuck with it. You're stuck with it unless you have some compelling argument. That's what the court was saying there. In that order, and since then, this court has made assumptions and used harsh words toward me because of those negative assumptions, which certainly isn't just. Normally, what someone would do if they're going to insult the court and accuse the court of using harsh words and negative assumptions is they would state specifically, in that order, the court said X. In that order, the court made Y assumption. You'd lay it out. You wouldn't just make a blanket statement. Oh, you've made assumption and used harsh words. This isn't an argument with your buddy when you're high, sitting on the couch, eating Doritos and drinking Mountain Dew. This is the judge's job. And normally professionals appear in front of that judge and make structured arguments. You said this, you said this, you said this, you said this, you said this. Ergo, this shows bias, this shows bias, this shows bias, and this shows bias. He continues, I am a pro se litigant. Well, thank you for stating the obvious, because I'm sure the court had no idea that you were a pro se litigant until you just said it. This is the first time I'm doing this. Well, that is not true, because if there's a little case out of Ironton that you were the plaintiff for, and I'm going to also assume that you've been the plaintiff in other cases, i.e. the two HPOs that you filed against Kate. Those are cases, and you lost those. So there you go. I should not be attacked for simply filing a motion. You weren't attacked for simply filing a motion. You were chastised for filing the same motion 6 times. There's a difference there. It might be subtle, but the context is really what's important here. The context is you had filed the same motion the first time 4 previous times, and the 5th time you were chastised. Don't do it again. And then you filed the same motion again. Not reading the plain language the court stated, instead trying to twist the court's language into saying the exact opposite of what the court was actually saying. So, yeah, it's not that you were attacked for simply filing a motion. You were chastised for filing the same motion 6 times. I'm, and then in bold, not only in bold caps, being attacked online. Attacked. So that's why I don't like these vague words. I don't think the court really likes vague words. Again, you should use examples. On this date, at this time, this was done. On this date, at this time, this was done. Using hyperbolic language like I'm being attacked doesn't tell the court anything. In fact, it undermines your argument because the court's going to infer that you being attacked online is Kate Peters saying mean words about you and calling you a quarter man on the internet. That's not being attacked. It's this cheapening of the English language that really undermines a lot of normal conversation. You have people who disagree with you calling you a Nazi or a racist or a homophobe. If you take pictures of people at the beach, it's harassment. I mean, the language is just, I'm being stalked because I keep telling people my location when I'm online and people listen to me when I say it. It just cheapens the language. That's why it's better to say, this is what happened. Say what happened. Don't say how you feel about it. Speaking of which, but now I feel like I'm being attacked by the judge and the clerk as well. See, this undermines your argument. This cheapens it. The judge knows what she's doing, and she knows that your reaction to it is unwarranted. And so she's going to say, well, if you feel attacked by me, chastising you for filing the same motion 6 times, especially after I said in very, very explicit terms that, no, don't do it again. If that's being, in quotes, attacked, then you being, in quotes, attacked online must be as equally as nonsensical. It must be equally as much of a nothing burger. You must just be simply oversensitive. When I say that all of the witnesses for a case are in Los Angeles, and I didn't know that I could have filed suit in Los Angeles, that is not simply a change of heart. Well, it is a change of heart because you filed it in one place intentionally, and then you changed your mind based on new facts. You figured out that you could have filed in Los Angeles. That's a new fact. which changed your mind. And again, I don't think you could file in Los Angeles. I think you're going to have a real problem with personal jurisdiction over Kate and Josh. I think you're going to have a real problem with that. And I don't think you could have brought this in Los Angeles. I think you would have not been able to do that because they would have challenged it for personal jurisdiction, and I believe that they would have prevailed. That is what transfer motions were designed for. No, it wasn't designed for people who change their minds. Normally, if the plaintiff selects the forum, if the plaintiff selects the court that you file in, then the defense would be the ones asking for the transfer of venue. Or if something happens where the defense asks for a transfer of venue, it gets transferred, and then new facts and information come out, and all of a sudden it makes more sense to have it back at the original place, then that's when the plaintiff would do it. But the plaintiff gets to pick where he files the lawsuit. You just picked poorly. Well, actually, no, technically you picked the correct forum. You just don't like that, and you want to try somewhere else. So it's not what transfer motions were designed for. The judge, however, knows what transfer motions were designed for. The judge understands the various factors that the judge has to consider, that the judge has to weigh in determining whether or not to grant your motion to transfer venue. The judge weighed those factors and found you wanting. It wasn't just because you had a change of mind or a change of heart. The court weighed all of the relevant factors. This court also seems to admit that I didn't make 5 motions asking for the same thing, but said it anyway just to be hyperbolic, or is choosing to interpret filings in the most prejudicial way toward me instead of the way that I most reasonably intended. No, see again, like the initial letter, the court interpreted that letter to be a motion. I would have interpreted it to be a motion because you were asking for something. The court can't then change its mind after you have filed 3 subsequent motions that you've titled motions that are asking for the same thing that you asked for in the letter and say, well, I guess you weren't asking for that in the letter. See, that doesn't make sense. It doesn't make sense for you to say, oh, when I was asking for the thing in the letter, it wasn't a motion, but then I went and filed 5 other motions after that, asking for the exact same thing I was asking for in the letter. See, you're the one trying to warp the language and the understanding of it. The most simple reading is that the letter was a motion asking for exactly the same thing as the other 5 subsequent motions asked for. That's the simplest, most rational way of doing it. When I ask for a hearing, in case you have questions that need answering, I'm not admitting to missing any argument that should grant the motion. I'm saying that this court seems to be very curious about my intent when I'm making motions, and instead of filling in those gaps, please schedule a hearing so I can answer those questions for you. I don't know that the court has been curious about his intent. Because see, when you file a motion, you tell the court, I want this. This is what I want. It's a motion. You filed your motion. You said, I want my voluntary dismissal to be entered nunc pro tunc before Kate and Josh filed their answers. The motion is literally asking, that's your intent. You state your intent in the motion. It can't be more clear. The court is not curious about your intent. The motion states your intent. I want this. It's like a grocery list or a Christmas list. Dear Santa, I want a new G.I. Joe doll for Christmas. Love, Chili. Santa doesn't wonder about your intent. You have told Santa your intent. You want a G.I. Joe doll. Action figure. the court doesn't wonder about your intent. He says, I can't go on a fishing expedition trying to guess all of this court's curiosities and trying to answer them every time I file a motion. The reason why people hire lawyers, this might come as a shock to you, but lawyers, generally speaking, tend to have a grasp of what the court is looking for. So the lawyer says, okay, I want to file this motion to get this result. The court is going to look at these specific elements. The court wants these specific answers. So these are the facts I have. This is the law. Am I going to prevail? Is there a reasonable chance for me to prevail? The attorney will then draft his memorandum of points and authorities. The points would be the facts. He would cite to a declaration, but the memorandum of points and authorities would recite the facts, and it would recite the law, and it would apply the facts to the law the same way the judge is going to apply the facts to the law. And the attorney is going to do it in a way most preferential to the outcome that he wants. So he knows what the court's looking for. If you don't know what the court's looking for, well, that's a problem. That's why you hire an attorney. So it shouldn't be a fishing expedition. You shouldn't be attempting to guess the court's curiosities, because there are cases out there that lay out all of the facts, all of the elements of each motion that you're trying to do, and the various things the various facts the court is going to weigh in determining whether or not to grant the motion. So you're being silly. I mean, the court is going to require you to give it the facts at a minimum. You've got to give it the facts at a minimum. And you don't know how to give facts because you say things like, I'm being attacked online. And that doesn't mean, it sounds like it means something, but it doesn't actually mean anything. It doesn't convey any knowledge. How are you being attacked? What does it mean to be attacked? How can you be attacked online? What specifically is happening? You don't give facts. You give your feelings about the facts. The trolls claim it is impossible for me to get a fair trial in this court. Again, who are these trolls? Is it the troll mafia? Why would the troll mafia claim it's impossible for you to get a fair trial in this court? How would they know? What's the basis for their knowledge to make this claim? You're being like, this is a nothing sentence. It imparts no knowledge. It is beginning to look that way to me as well. Well, that's passive aggressive as fuck right there. Like, Jesus Christ, change your tampon, dude. It's beginning to look that way to me as well, daddy. Anyway, that's the end of that. On a completely different note, Earl Warden, he's going into... He got through day one. To the best of my knowledge, there were 3 witnesses that were done today, which is weird to me because normally you lead strong, and I believe these were very strong witnesses for the prosecution. And getting through 3 of your main witnesses over this is just amazing to me. But I did look at the witness list. These are all the subpoenas that go out, and they've pared down their subpoenas this last bout. They've pared down their subpoenas to, it appears to be about 10 subpoenas, which, okay. So, mea culpa. I didn't realize that they had pared it down from about 20 to about 10 subpoenas. And I also didn't anticipate getting through the 3 of the main witnesses on the first day. So apparently, I'm not 100% sure on this, but I've had a couple sources tell me, i.e. Earl and a witness who was there at court, say that the judge was anticipating that this would be submitted to the jury on Wednesday, which again is mind-boggling to me. I am just, this is pure assumption on my part. The only reason why I could think that the defense is just kind of letting this go and not doing a real extensive cross, because I can't imagine why, other than it's just bad for Earl. It's just all bad news for Earl, and there's nothing good to cross on. So the fact that it's going this fast, I don't think is good for Earl. Now, I could be 100% wrong. I am just a first-year family law attorney. I have not witnessed any of the trial. This is me just essentially pulling this out of my butt. But my gut instinct is if it's going this fast, that's probably not good for the defense. But, what do I know? Anyway, thanks for watching, and have a great day.